So it is now my pleasure to welcome special needs and estate planning attorney and judge of Gwinnett County Magistrate Court, DJ Jeyaram. DJ shifted his law firm's focus to helping families with special needs in 2009 when his son was diagnosed with a rare genetic condition. DJ specializes in special needs trusts, wills, guardianship, conservatorship, and appealing Katie Beckett and now and comp denials. In addition, DJ's experience includes serving as the Deputy Director for Legal Services with the Georgia Department of Community Health and as a Georgia Administrative Law Judge with the Office of State Administrative Hearings. In his role as an Administrative Law Judge, DJ presided over Katie Beckett and now and comp hearings. DJ, thank you for being here with us today. I know I'm really excited about your presentation, and I think I'm not the only one by the number of parents that registered and are attending this webinar.
Thank you for having me. I really appreciate it. It's a topic I love to talk about. As a special needs parent, nothing keeps me up at night like wondering what is going to happen to my child when I'm not around and my wife is not around to do all the things that we do for him. And a good special needs estate plan really is the answer to that question. So I'll just go ahead and jump off into it. And so what we're going to cover today, we're going to talk, of course, about the special needs trust, how that works, why you may need it, and some options on how it's created. I'll talk about ABLE accounts. That's something that whenever people are talking about trusts, the ABLE account always pops up. And so we'll talk about how that ABLE account fits with the special needs trusts, how they work together to help protect your child. Of course, we'll talk about wills and some of the special needs specific decision making that goes into a special needs will. And then we'll wrap up with a discussion of guardians and trustees. How do those two roles work together to provide protections, not just for special needs, not just for the special needs child, but for the trust as well. So making sure that the plan not only serves to protect assets, but protects the child themselves. So I'm going to go ahead and jump off into the presentation. As Cindy was saying, I've been practicing for 25 years. I was a administrative law judge, which really kind of helped me focus my practice on administrative appeals like now comp and Katie Beckett denials. But since my son's been born for about the last 15 years, we've been doing special needs estate planning. That is the only kind of estate planning we do. We will help out, family members of the special needs family, but we don't do elder law. We just focus on special needs estate planning, guardianships, powers of attorney, and how to help special needs families in any way we can. I do need to say that this is, of course, my family, and this is why I do what I do. It's very important to me that families get good, understandable information. That's information I didn't have when my son was born until I found the right people who to educate me, and now I greatly enjoy paying that forward. I do have to put this slide out there, of course. This presentation is for general educational purposes. This is not legal advice directly to you. If you have any specific questions, feel free to reach out to me. I'll provide my information at the end of the presentation. Okay, so let's get into the meat of the presentation. In terms of protecting your child's benefits, you're going to have three major vehicles. One, of course, is the special needs trust. The second is the ABLE account, and the third is a will. But let's talk about the special needs trust first. So the purpose of the special needs trust is to protect what we call resource-based government benefits. Well, what is that? That's SSI, Medicaid, Katie Beckett, and the now comp benefits. So for SSI, when your child turns the age of 18 or older, That's a resource-based benefit, meaning they cannot have more than $2,000 in their name and continue to qualify for SSI. Well, why is SSI important? Well, adult SSI in Georgia automatically comes with adult Medicaid and a cash benefit. Now, if you don't have adult Medicaid and you're looking for Medicaid for a child, but your family may be over income for low income Medicaid, that, of course, is Katie Beckett, which I'm sure many of you have heard of. Well, Katie Beckett is also a resource-based benefit, meaning your child cannot have more than $2,000 in their name and continue to qualify. So if there's a bank account, a savings account out there in your child's name that has more than $2,000 in it, that could keep them from qualifying for Katie Beckett. Now, once you have Medicaid, whether adult Medicaid through SSI or Katie Beckett, if your child is under the age of 18, that opens the door for application and possibly getting a slot for the now comp waiver. So you see how all of those benefits fit together. But the key to all of that is keeping and maintaining your eligibility for Medicaid. So that means not having $2,000 in your child's name at any one point. So that's where the special needs trust comes in. After we pass away, or sometimes even before, if you put money or assets into a third-party special needs trust, the government ignores what's in the trust in terms of determining your child's eligibility. So that becomes really important because when we pass and we want to put money away for our child's future support, where do we put it so it doesn't interfere with SSI, Katie Beckett, Medicaid, now comp waiver? And that is the special needs trust. Anything you put into it, the government ignores in determining your child's benefits. There are a couple other benefits to the special needs trust that it has in common with all trusts. Sometimes the trust will protect assets in it from your creditors or the child's creditors, because anything you put into the trust belongs to the trust. It does not belong to the child, does not belong to you anymore. It belongs to the trust as its own legal entity. So that means if you get sued, if your child gets sued, if the special needs trust is irrevocable, cannot get your creditors cannot get to it because it doesn't belong to you anymore. It belongs to the trust. It's protected not just from creditors, but predators. So if your child is susceptible to being influenced and mom and dad may not be around anymore to help guide them, and people are trying to take advantage of them to get to their money and to get to their assets. Well, the child may have some assets in their name or assets they control. Nothing over the 2,000 limit, hopefully. But special needs trust. So not only are you protecting from creditors, but you're protecting from predators. And another really great thing about the special needs trust is, of course, you choose who the trustees are. If you're creating the trust while mom and dad are still around, mom and dad or mom or dad can be the initial trustee. But you also get to choose who the successor trustees are, who comes after you. And it doesn't just have to be the first person who comes after you. You can have an entire line of succession of the people you want to succeed you to control the assets to help your child. You can name as many people as you want. You can name a mechanism by which if all those people are gone, how do I choose somebody? Because when we're building a special needs trust, if something happens to my wife and I tomorrow, my son's trust could last 70 years. Well, that's a long time. Everybody I would choose for trustee today will pass before the 70 years is up. So how do I know who comes after them? Well, I may not know names, but I do know mechanisms. Maybe I want the then acting guardian of my son and my daughter to agree on who the next successor trustee is. So you can build mechanisms by which successor trustees are chosen. But that's what the special needs trust is, to maintain eligibility for SSI, Medicaid, Katie Beckett, and the now comp waivers. So when we talk about special needs trusts, there are really three kinds of special needs trusts. I'm just going to touch on this briefly because I know a lot of you will go out there and do your own research on Google. And this is one of the first things that comes up. A discussion between first person and third person and pooled special needs trusts. What a first person special needs trust is, it's a certain kind of special needs trust that should only be funded with money or assets that belonged to the beneficiary, to the special needs individual who that trust is supporting. So if your child has an inheritance coming from a grandparent, and that inheritance names the child themselves, so that's the child's right to collect that inheritance, well, that can endanger their benefits if it's over $2,000. So that's where something like a first person special needs trust could be used. You take the money out of the name of the child, you put it into the first party special needs trust, and once it's in there, the government will no longer consider it in determining that child's benefits. So that's great. The downside to a first party special needs trust is at the end of the beneficiary's life, to the extent that Medicaid is paid anything for their support during their lifetime, Medicaid can take what's left in that first party special needs trust. So you want to be very careful when you use this kind of trust. It generally is to be avoided if at all possible. The preference is to use what's called a third person or third party special needs trust. Now, it's called a third party special needs trust because it is funded with money or assets that never belonged to the beneficiary. It belonged to mom or dad or whatever source it's coming from, and then it was left directly into the third party special needs trust. So in things like a life insurance policy, instead of naming the child, you're going to name their trust. If the money and assets pass that way into the third party trust, it was never owned by that special needs beneficiary. If it was never owned by them, whatever is left in the third party special needs trust when that beneficiary passes away, Medicaid cannot take it. It goes wherever you have designated in the trust it goes. So for most people, what it'll look like is naming on your life insurance, on your 401ks, on your investment accounts, whatever you're going to leave to the special needs trust, you name the special needs trust as the beneficiary. It's going to flow directly from those funding sources into the trust and be used during the special needs beneficiary's lifetime for their support. And when they pass, most parents who created the trust will list where they want the money to go. Generally, it can go to a sibling or another child of the parents, or it can go to grandchildren, or it can go to charity, or it can go to a church, it can go or research, and go wherever you want it to go, but it doesn't have to go to Medicaid. So that's really the big difference between the two. There is a third option. The third option is what is called a pooled special needs trust. What a pooled special needs trust is a already created special needs trust that is run by a company. There are different kinds of companies, banks, trust companies, special needs organizations that run these pooled trusts. So it's a giant special needs trust that is created that you as mom or dad, or if it's a first person version, even the individual themselves, can open up an account within that pooled trust. And that trust pools all the resources for many different people. So lots of different special needs individuals will open up accounts. The pooled trust has lots of professional management under it. It has attorneys and CPAs and financial planners and benefits experts all underneath it. So a lot of built-in expertise with the pooled trust. Pooled trust is great for some people. For others, they tend not to like it because the pooled trust is a one-size-fits-all trust. You're not building a specific trust for your child. You're utilizing someone else's created trust. So if you if having a specific trust for your only for your child is important to you, then you want to consider a third person special needs trust for your child. If you want to consider all that professional management and maybe less upfront costs, you might want to consider a pooled trust. But those are the three major options. Each one has a pro and con. If you can avoid first party, first person special needs trusts, you probably do want to avoid that to avoid the Medicaid payback. An individual third party special needs trust for your child is specific to your child. You can build in the rules, how the money's to be used, and who all the trustees are. And with pooled special needs trusts, you have a big company or big entity running that pooled trust in which you open up an account and your child can use it. Generally, that company is the trustee. Depending on the company, some of them have a co-trustee who can be a family member, and others have are don't have co-trustees. They're just the trustee and communicate with family members to determine what the child needs. So those are your three major kinds of special needs trusts. So what can you use a special needs trust for, and what can't you use it for? And I will caveat this with, with the rules can change. So as of today, you can basically use a special needs trust for any purpose to support the special needs beneficiary of that trust without affecting their government benefits, except for payment of shelter. If you use funds from the special needs trust for payment of shelter, there is the potential of reducing any SSI cash benefit that child receives. So I'm not going to go into that rule right now because that's going to be very specific, but just be aware as you're thinking through what trust is right for you, how it's going to be used, that you can use the special needs trust for any purpose without affecting benefits except for shelter, which can affect the amount of benefits your child receives. So how do you address shelter? There are two major ways to address shelter. One is if you want to have shelter available for your child, a house, a condo, a townhome, you want to leave something so they always have a roof over their head if mom and dad are gone, you can leave it to the trust. And in that sense, the trust owns the residence, and your child will pay some form of rent to the trust. So there's no reduction in benefit in that situation because the trust is not paying for the shelter. Your child is still paying for their shelter out of their public benefit. Gets paid up into the trust like a landlord, and then the trust can hold on to that money to come back around and serve your child. So that's one of the ways to address shelter. Another way to address shelter is through the use of the ABLE account, um, which I'll get into right now. So what is an ABLE account? So just to begin with, an ABLE account in Georgia, the Georgia version is called stable. I understand what they were going for. They were going for state able, but It makes life a little bit difficult, but Georgia calls their version stable. So why would you want an ABLE account if you have a special needs trust? They do similar things. They protect resource-based government benefits like SSI, Medicaid, Katie Beckett, and now COMP. Anything in an ABLE account to a point, which I'll talk about in a second, the government ignores in determining your child's benefits. So that way it's very similar to a special needs trust. Like a special needs trust, friends and family can contribute to it. I'm sorry, like a third-party special needs trust, friends and family can contribute to an ABLE account. One of the really nice things about the ABLE account that is a little better than a special needs trust is its tax treatment. When you put money into an ABLE account, you've already paid income taxes on it, or whoever's contributing has paid income taxes. They put it into the ABLE or stable account, and normally there are investment options within that account, different kinds of mutual funds. You can invest in those funds, and then any income made on those funds within the stable account grows year to year, income tax free. So that you can have years of nice compounding interest. And then eventually, when you use the funds for the benefit of the special needs individual, it remains tax free. So that's a really nice tax treatment. In contrast, a special needs trust is taxed every year on its income. So you have investments within the special needs trust. The mutual fund makes some interest over the course of the year. Any income that remains in the trust at the end of the year, the trust has to pay income tax on. So different tax treatment between a special needs trust and an ABLE account. An ABLE account, it's really easy to access the funds. The ABLE account legally belongs to the special needs individual, and they open it with the help of someone else, a guardian or someone with power of attorney. It's easy to open up. It takes just a few minutes online. If you've ever opened up an online bank account or investment account, it's a very, very similar process. A lot of ABLE accounts come with debit cards. So if you want to have your special needs child or loved one have some access to funds directly without necessarily going through a trustee to get to the assets in the trust, this can be a way to do it. But the ABLE account is a really important, nice asset to have. Now, there's some limitations to the ABLE account on how it differs from a special needs trust. The very first one, and in my mind, the most important one, is just like a first-party special needs trust, the assets in an ABLE account belong to the special needs individual. And if it belongs to them at the end of their life, whatever is left in an ABLE account, from the time the account is opened to the time in which that individual passes, whatever Medicaid is paid for their benefit, Medicaid can take what's in the ABLE account. So first party special needs trust, Medicaid payback. ABLE account, Medicaid payback. Okay. So to the extent that you have money in there and you would have rather gone to another child or a loved one, Medicaid gets first bite at that apple. The second big difference is there are limitations on ABLE accounts that are not on special needs trusts in terms of the amount you can put into it. For an ABLE account, this year, you're limited to $19,000 contributed to the ABLE account during the calendar year. Now, that's from all sources. You can only have one ABLE account per person. So if my son has an ABLE account and my dad wants to leave $10,000 to it that year, then I can only leave 9 before hitting that limit. At 100,000 in the account, benefits get suspended, not terminated, but suspended. But 100 is a nice round number to remember. So if you do start bumping up against 100,000 in an ABLE account, that's a great problem to have. But if you do start bumping up against it, that's probably the yellow flag. Go talk to a financial planner or a CPA and try and figure out, is it worth it to go over that amount and get benefits suspended or not? Now, in terms of limitations, that 19,000 does change a little bit if your special needs loved one is working and wants to contribute their salary to the ABLE account so they can earn money, but not accumulate it to the point where it affects their benefits. Where do they put it? That can be the ABLE account. So the 19,000 does go up in that situation. The other thing to remember about the ABLE account and a difference from a special needs trust. An ABLE account can only hold money. And then once the money's in there, you can invest it in mutual funds governed in that ABLE account. It cannot hold things. It cannot hold a house. It cannot hold ownership in a business. It cannot hold a wheelchair van or a vehicle. It cannot hold a pet. It cannot hold anything like that. So to the extent there are assets other than cash you want to leave for your loved one, an ABLE account is not going to be an option, but a special needs trust is. I already talked about the use, you can use ABLE account funds for any purpose to support the individual, including shelter, and not have it count against their benefits. And I already talked about the no tax on growth and income within the ABLE account. The bottom line is most families have both. I know, for my family, I have a special needs trust for my son. I also have an ABLE account. I've not funded the special needs trust yet. That's there, ready to accept funds or assets when I pass or my wife passes. We do put some money in the ABLE account. We're trying to take advantage of that nice compounding interest year after year. So we just put a little bit in every month and just hopefully watch it grow. We understand the risk that if something happens to my son, who's been on Katie Beckett since he was eligible as a young child, we fully anticipate that, God forbid, anything happened to him, all those funds will be lost. It will not go to my daughter. We anticipate Medicaid will take it, but that is the risk that we are taking for that really nice tax treatment. Okay, so we've talked about the trust and the ABLE account. We've talked about how those are used to protect benefits in slightly different ways and how they can complement each other and the pros and cons of both. Let's talk about your will. In your will, you're going to have a series of important decisions, some big, some small. I'm just going to focus on the special needs specific decision making when it comes to the will. Number one is the will can be a roadmap of your wishes on what you want to have happen with certain assets, where you want it to go. It's the flow of your estate. What I mean by flow of your estate is if something happens if there's a couple, two parents in the family, and one parent passes, a lot of times 100% will flow to the other parent. That's fine. The harder decision is usually what happens when all the parents are gone and you have more than one child. Special needs trust is for the special needs child. You might have a regular trust for the regular child. There are circumstances where a typical child and a special child can share a trust. I'm not a big fan of that, which I'm not going to go into tonight. But we always suggest that the special needs child have a special needs trust and the typical child have a typical trust. In that situation, you're going to have to make a really hard decision now as your documents are drafted How do I split my estate between a typical child who I love and a special needs child who I love, but have to acknowledge that the special needs child may have more needs throughout their lives than my typical child? Maybe it's 50-50, maybe it's not. I always encourage parents to think beyond, hey, I love them the same, so I'm going to leave it the same. A lot goes into that decision. One of the biggest pieces to go into that decision is right now, do you anticipate that government benefits will be there as they exist today? Or do you want to plan to fund the special needs child's trust like those benefits will not be there for them in the future? So if you're lucky enough to have a now comp waiver slot and you're getting an annual budget of $50,000, $60,000 a year in benefits, well, that's incredibly valuable. Katie Beckett's valuable. Adult Medicaid is valuable. Well, if those things are gone and the trust has to step up to fund that shortfall, how much money does that trust have to generate? It's not an easy question, but it is one of those things you have to contemplate, because if you want to anticipate a potential shortfall because benefits are gone, you're going to have to fund that trust with more money. If you are comfortable with, look, I think benefits will be there and more or less as they exist today throughout the life of my child, or hopefully better, you may not have to fund it as aggressively. And there's no right or wrong answer to this. This is just your own personal philosophy on how to fund the trust. Another big decision in your will is, what do we do with your primary residence? What do we do with that? Because it's not just an asset, it's a home. And so if your child is living with you right now, or children are living with you, and something happens to mom or dad or both in the next 5 years, we want to make sure there's a specific plan for this very important asset. And the plan could be, we want to keep the house and maintain it in some capacity in one of the trusts or multiple trusts. Or look, we plan on our kids going to live with a guardian in a different state or a different county, or to just go live wherever the guardian happens to be living in their home. And so we want the house sold and the cash derived from the home split between the trusts in some capacity. Those are two very different visions for your children's future. Staying in the home, where a lot can stay the same: neighbors, their rooms, their yard, their school system, their friends, um, your primary care physician, your therapists. All of that can stay the same if the house stays the same, or they stay right in that area. If they move out of the area, all those things will change. And that's not to say one decision is superior to the other. It's just a fact that if you move out of the school system, the school's going to change. Doctors will change, therapists will change. So really kind of think it through. Ask all the micro questions in trying to arrive at the best decision for your family. You're going to name successor guardians in your will. If something happens to mom and or dad, um, who comes next? Who's going to step into your shoes? This is the major reason people do not do a will, is they don't want to answer this question. But I will tell you this: if you don't make your choice of who comes after you, a court will. A judge will look at the statute, see who's stepping up to be guardian, and they will choose somebody. And you are in the best position to make that call, not a court. So don't ever let this keep you from getting your documents done. You have to make these hard decisions for yourself. And finally, if you have a will distributing assets, distributing money or items, it does tend to cut down on conflict and family drama after we're gone. I'm sure we all have heard at least one story of people fighting over a parent's estate. It is among the worst things you'll ever see. A really well-drafted will that is specific and clear does minimize family conflict and drama. Um, the financial protections, like I said, that go along with the trust is protecting from both creditors and predators. And one of the other things that I really like about having a good, knowledgeable trustee in charge of your trust is they create a check and balance with the guardian. Well, what does that mean? Well, we always really like to see guardians and trustees after the parents are gone to be different people. Well, why? And it's or mom and dad as legal guardians. You can exercise the legal rights of your child on their behalf. Well, among those rights are potentially suing the trust or the trustee if they're doing something wrong with the trust. The guardian can intercede, they can file something, they can do something about it. Likewise, the trust can be utilized to make sure people are looking in on the child physically, making sure they're physically and mentally okay. Because while we trust the guardians and trustees we're choosing today, we cannot tell the future. And people change. We've all seen it. People have changed in our lives. It's not that they turn bad and they're stealing the money or not paying attention to the child, though that does happen. But what if it's Alzheimer's or dementia or divorce or substance abuse? Things we cannot necessarily anticipate. Well, we can't take chances with our child or their assets. So no matter how much we trust somebody today, I always encourage creating these checks and balances to make sure our child is physically, mentally safe, secure, and happy, and that the trust is safe and secure. Okay, by creating those checks and balances. Having a good trustee, that trustee is going to be in charge of making sure that the assets in the trust are reasonably invested. You don't want all your assets sitting there making 0% income. Income generation in the trust might be part of your financial plan on how to afford to pay for all the things your child needs. So if it's generating income in the trust, if you use it, great. If you don't use it, that trust can grow and it'll be a greater asset there for your child in the future. And if your child never uses it, if it's a third party trust, the trust has grown and then you can leave it to another child or to another cause or to another person that you've chosen. So having good, knowledgeable trustees is super important. Like I said, keeping them separate, checks and balances, um, protecting the trust and the child themselves by letting the guardian intercede if the trustee is going off the rails, and letting the trustee intercede if the guardian has gone off the rails. If you don't have enough people to serve all these roles and keep everybody separate, that's okay. We know that being a special needs parent is hard. Sometimes we get isolated and we don't necessarily have a lot of family or friends willing to serve, and that's okay. There are other ways to build in protections, and that's co-trustees or the creation of a trust protector. We can do all those things. But conceptually, what I'd encourage you to do when you're talking to your attorney is just keep in your mind that concept of checks and balances, multiple sets of eyes on the trust, multiple sets of eyes on the child. Ultimately, having a good estate plan is a team effort. We work consistently with financial planners and CPAs. We can create the trust, we create the buckets, we create the legal and physical and financial protections within the legal documents. Okay? We can't tell you how to fund it. We can't tell you how to balance it for maximum effect. That's where things like financial planners and CPAs are critical parts of the team. I like to think of the attorney kind of as the quarterback of the team, where we make sure we connect you with those right people to assist in areas where we shouldn't be, and certain areas where your financial planners and your CPAs it should not be drafting legal documents. So it really does take a team to assist you. How do we use legal tools to protect our child? And this is where I'd like to talk about guardianship. and powers of attorney. These are the two major avenues in which we, as our children become adults at the age of 18, how do we make sure mom and dad still have some sort of authority to help their child with all the things they need help with, whether it's a lot or a little? And so the two major options are guardianship and power of attorney. There is a concept out there called supported decision making, which is not a um, legally recognized concept in Georgia, but it may be coming and hopefully in the near future. But who's going to need a guardian? Well, of course, all minors, everyone under the age of 18. I think everyone knows that. But as your child becomes 18 and legally reaches the age of adulthood in Georgia, for mom and or dad or parents or loved ones to keep decision-making powers, if it's under guardianship, a court, your local county probate court, must go through the process of guardianship where it is adjudicated, where that judge decides that the child who's now become an adult cannot make reasoned decisions about their own health, safety, and welfare. Powers of attorney are another option. Now, I'll give you the pros and cons of each in a moment. But the question I get quite often is, when do I start this process of deciding between power of attorney, guardianship, supported decision making? I always suggest 17 and a half. That 6 month period gives you time to think about it, talk about it, sleep on it, talk to other families about their experience, and then ultimately decide what is best for you and your family. Like I said, the standard for guardianship in Georgia, the court may appoint a guardian if they find the adult, 18 or older, lacks sufficient capacity to make or communicate significant responsible decisions concerning his or her health or safety. Note this does not say good decisions, okay? Lacks the capacity to make them, okay? And so a lot goes into the court determining that. But if it was bad decisions, then I don't have any 18-year-olds in my family yet, but I have a lot of friends who have 18-year-olds, and they're worried about them, totally typical, worried about them making good decisions. So just note that it's not just that your child may make bad decisions, it's that they lack the capacity to make responsible decisions. So a couple words of advice on guardianship. There are several rights that are taken from the child in the guardianship process, the adult child, and given back to the guardian. Among those are medical decision making. Child no longer has that, given back to the guardian. The right to enter into contracts, taken from the child, given back to the guardian. And one of the ones I like to mention briefly, and I want to leave time for questions, so I'm just going to touch on it lightly, and that is interaction with law enforcement. This is one through my judicial background I'd like to talk about, because I do think I have kind of a unique perspective on this. And that is, we see a lot of people in the criminal justice system who are intellectually disabled or mentally ill. And first responders, law enforcement aren't always trained on how to recognize the difference between the two and how to deal with it. I'm sure we all see, and when we watch the news, it seems about every month or so, we see a news article about somebody with special needs running afoul of law enforcement. And so if you have guardianship in place, one of the things that I like to remind parents of is a court of competent jurisdiction has already adjudicated the fact your child cannot make reasoned decisions about these important things. And so if you think your child may have touched someone's arm inappropriately or knocked over something or destroyed something by mistake, and law enforcement's called and they're trying to figure out whether they're going to make an arrest or not, I always like to encourage people to understand that to tell law enforcement A court of competent jurisdiction has already adjudicated the fact my child cannot make reasoned decisions about these really important things. That means they cannot form criminal intent. That's the phrase. Now, ultimately, it's going to be up to that officer whether they buy that or not, whether the judge later on down the road buys it or not. But I think that is an absolutely valid legal argument. I've raised it to prosecutors and judges who I work with and have never heard anything to the contrary. They said, look, that's valid. So, a couple practical decision-making tips for guardianship. When you're choosing the guardian, successor guardians in your will, ask all the micro questions about how to choose a good one. How old are they? Do they have the ability? Do they have the patience? Do they have an established relationship with their child? Where are they? Are they in Georgia? Are you going to be able to maintain your state-based benefits? Or are you moving out of state and have to start over with certain benefits? Are they stable mentally, physically, emotionally, financially? Ask all the hard questions. Don't avoid them. When you have those, when you think that through, you're going to end up with better decisions on a guardian. The major alternative to guardianship in Georgia will be powers of attorney. Powers of attorney is a situation where your child does not lose any rights. Okay? They maintain all their rights as an adult in Georgia, but they're authorizing normally mom and or dad to exercise those rights on the child's behalf. The parent becomes the agent for the child. And so the parent can go out there, and if they're authorized, they can make decisions on healthcare, on finances, on education, pretty much anything. But do understand under powers of attorney, your child still has all the rights to make those decisions for themselves as well. So just because they let mom and or dad as their agent go sign a contract and bind them, the child can likewise go out and sign the contract because that right is not removed from them. So be aware of that. Be aware that once they sign, your child signs the power of attorney, they can revoke it at any time. They can fire you and have someone else choose somebody else as their agent. So ultimately, there's lots of pros and cons between the two. There is no right answer. There's only the right answer for your family. So don't let anyone ever guilt you into one choice or the other. You know your family and your child best. Make the best decision for your family. But ultimately, the difference between the two is who has final decision-making authority. Under guardianship, it's the guardian. Under power of attorney, it is the child, the adult special needs child. So if you have an opinion that differs from theirs, you're their agent, you work for them, their opinion trumps yours. So just be aware of that difference. There's, of course, supported decision making, which is a hot topic in our community these days in Georgia. Supported decision making, in a nutshell, is a process by which your special needs child keeps all of their rights, and we as parents or other caregivers put mechanisms in place to assist them in learning how to make good, reasoned decisions for themselves. That is a laudable goal. I love that. And I certainly think that is something that can be effectuated both under powers of attorney and guardianship. The best parents I know who happen to have guardianship right for their family still allow their children to learn these processes. They're still teaching them how to make good decisions. But ultimately, the parent has the decision-making authority. Same thing with power of attorney. And just because our kids become adults and we have power of attorney or guardianship in place, doesn't mean we stop being parents. It doesn't mean we stop trying to educate them on how to make good decisions. Now, in the future, supported decision-making does become a legal option. an alternative to power of attorney or guardianship, then this discussion is going to change a little bit. We'll have to talk about the pros and cons of that option as well. But we're not there quite yet. Something I encourage people to do is in your estate plan, try and capture as much information as you can about the particulars of your child. Who is their primary care physician? Who's their therapist? What meds are they on? What are their allergies? What is their favorite food? And then capture things unique to your child. Bedtime process, bath time process, taking meds. Because we're preparing these estate plans long-term in mind, but we're also preparing them in case of an emergency. If something happens to mom and dad unexpectedly, and if your guardian has to step into your shoes unexpectedly, we want information in your estate plan binder that says, this is my child, this is what you need to know on day one. This is how you put them on the bus. This is when the bus comes. You have to lay out their clothes the night before to avoid the meltdown the next morning. Whatever it is, capture as much as you can and preserve it in your estate plan for use by your guardian should they ever need it. A couple final words of advice. If you do choose an attorney to help you with your estate plan, pick somebody who specializes in this area. Okay, it is not intuitive unless you're a special needs parent. The best attorneys I know who do this kind of work are special needs parents. I'm not just talking about me. There are lots of other really good ones out there. But someone who understands your life and kind of plugs the holes and addresses the concerns. Because a good special needs plan is not just about the legalities. It's about the practicalities of protecting your child and making sure they're provided for. You don't have to have all the answers before you contact an attorney. We used to be called counselors at some point because we used to advise people. So a good attorney is not just going to say, fill out this questionnaire. They're going to talk to you about it. They're going to go through it with you. They're going to help you think it through for you to make the best decisions you can for your family. And finally, you can always put something in place now. And as long as you're around, it is not hard or expensive to make changes. But you have to have something in place. There's no half protections. You either have your documents executed and in place or you don't. So I encourage people, let's get something in place, make the best decisions you can today, knowing tomorrow, the month after, the year after, 10 years later, you can always make changes. And I think that's about it. I'm glad to take any questions. I do have my information up here. If you have any specific questions about your situation, feel free to email me or call my office. I'm glad to speak to people.
Thank you so much, DJ. That was very informative.